trying to do is put together a small but mighty group here representing a diverse array of perspectives on this issue. And we'll say more by way of their background and give you more context as they address the question. So I'm going to just briefly identify them for you as we go forward. The first is journalist Alan Judd, who's a reporter with the Atlanta Journal-Constitution. And Alan was the author of the most recent expose on child fatalities, and we thank you for that sort of revelatory look at these issues. Next to him is child welfare attorney, child advocate Tom Rawlings, who has formerly held posts as the state child advocate appointed by Governor Perdue, and also prior to that as a juvenile court judge in the Middle Judicial Circuit, so represents a broad set of perspectives himself in many capacities. And then also Rachel King to his right. Rachel King is the legal counsel for the Department of Human Services. And again, I just want to thank you and credit you for being willing to engage at this level in these kinds of conversations. As you can see, and as we sort of tried to note just in identifying folks, everyone's got, again, their own perspectives, certainly their own opinions, their own grounding in these issues. I want to note that they have also their own constraints with respect to addressing the questions that we hope to pose today. And in particular, in anticipatory defense in some ways of Rachel King, who's been willing to join us, you all can appreciate that though the agency often bears the brunt of the criticism and is in this sort of hottest seat in the spotlight, as an administrative agency, they're not the ones who make the laws, they're the ones who follow the laws as they're written and as they're interpreted. And so in that ways, you may find that we have certain constraints in our ability to respond to the questions as we pose, particularly as they relate to policy and the progression of policy going forward. So I just want to note that on her behalf. And with that, we're going to go through a few questions that we've had already prepared for the panel and that they've been sent in advance. And then as we go, we'll see how it goes. We may open it up to the floor for some of your questions as well. Panelists, we're going to juggle the microphone. And I've been told that you have to speak directly into the microphone in order for it to be picked up and broadcast for the group. So I'll do my best to remember to send that your way. So as we start, the first question is really to allow you all to give some more insight into your perspective and role with respect to these issues. So I'd ask that you briefly comment on you or your agency's perspective or experience regarding the issues of confidentiality in child welfare cases. I'm actually not sure how far this is going to go. So while you answer, Alan, I'm going to untape the microphone here.
Thank you. From the perspective of the AJC, obviously confidentiality constraints make it difficult for us to do our job, which, in our view, is to serve as sort of a watchdog for the system and really a stand-in for the public, people who need to know or want to know what's happening in a government agency that's very critical to the welfare of children in the state. And they obviously, everyone can't take the time or have the ability to get information that reflects how good a job they're doing or not doing, or as the case may be. So that's really our role, and obviously we have a vested interest in having as much information as possible that's to be public. At the same time, we are very, very aware of privacy issues, like everyone else, I think. But we sort of draw a distinction between children who are living and children who have been killed or who have died after having some contact with the system. The living children, I think everybody, as Judge Deal said, that they are going to have something sticking with them the rest of their lives, and we don't want to make that worse. We don't want to leave it out there in the public realm that people can search their name on Google or whatever years from now and find that. A child who has died, I think our position would be that the privacy rules concerning those cases are not really protecting the child at that point. The child is unfortunately deceased. It's protecting, in some cases, the parents or caregivers who might be responsible for the child's death, or at least in an indirect way. And to some degree, it protects the interest of the state employees who worked on a particular case, the state agency, in this case, defects. So that's sort of where we're coming from, is that we believe that we really do have a responsibility to keep up with how these kinds of cases are handled, And again, it's really trying to give a voice in many ways to the children who have died, because most of them are not kids who would necessarily be known otherwise. They are often poor and from dysfunctional families, obviously, and this is the only chance that anyone ever has to know who they were.
All right, good afternoon, everybody. Thanks for being here. This is actually I feel like I'm kind of in the middle here today, but I am in the middle in a lot of ways in what I have, in my experience. I actually grew up in the newspaper business. My sister was editor of our small town paper in Sandersville, and actually I was an intern at AJC about 25 years ago. And I've also been on the other side as a judge, kind of like Judge Deal. You deal with these issues. There are different things that strike you. You go into the local Walmart and people walk up to you and start telling you about their case, and you are asking you about a case they've heard about. You can't talk about it. You work with social workers who are there working in good faith in very difficult circumstances, and often feel that they cannot talk about what they do is, because they have a job that is to protect people, protect the privacy of children. And of course, as a juvenile court judge, you are yourself bound by confidentiality provisions, and sometimes you feel that you can't go around and talking about what you do, unless of course you go to a judicial conference in which everybody talks about what they do. And then you run into the situation where the public doesn't really understand the problem. And so you find yourself in this world trying to balance the fact that you really do need to protect children from the public view, from the public eye. You do need to make sure that they are protected and safe. I think worldwide, courts and agencies make very strenuous efforts to protect the privacy of children who are abused, who are involved in delinquent activity, who are involved in bad situations. And at the same time, those of us who work within the system often think, I believe, that if we could simply explain what is going on to the public, that the public would better understand this work. The public might actually become more engaged in the work. And so what we have in the law, I think, is reflected. Or we have provisions both in the federal law, which is generally the capital law, as well as in the state law, which generally make these types of records private. But there is an exception, both in the federal and state law, for records and information regarding children who have suffered a fatality or a near fatality. I think one of the issues we need to deal with today in this panel is, what is the purpose of that law, what's it there for, and how do we properly balance the need to protect children, our duty to protect children, our duty to follow the confidentiality provisions of state and federal law, and at the same time allow those of us, especially our colleagues in the press, for example, whose job really is to help the public understand the system and what goes on with the system, and help the public improve the system. How do we let the public in sufficiently so that they can play their proper role in this system as well? So hopefully we can answer some of those questions today.
Good afternoon, and thank you for coming. I'm Rachel King. I'm with the Department of Human Services, and as Melissa alluded to, I'm the restriction. I'm the part that can only, we're an administrative agency. We administer what the legislature passes and release the information that we're permitted to release by both federal and state law. So with that as the caveat, our perspective, and just to kind of hit on a little bit of what Mr. Judd and Mr. Rawlings said, is very much constrained by what we're discussing when we talk about releasing information. We're talking about the fact that there needs to be information released so that the public can have it, so that the public can be engaged in the process. And one of the things I think that is imperative in the discussion is what information needs to be released. Because we have an open records law in Georgia, the department already does release records that detail accounts of actions where a child has died in a near fatality, where a child has died or there has been a near fatality. I know everybody has seen the news reports where we've got heavily redacted documents from DFACS, and there's a question of what in that information has been redacted. Obviously, no one except DFACS knows because no one has seen it. And perhaps that's where some of the question lies, whether or not we're doing the right thing. And I'm not sure that's a question that the panel can answer here today. However, I can assure you that that information is not being redacted by case managers. It's not being redacted by anybody that would have a vested interest in keeping that information secret. There's no reason for that information to be redacted except for what is required by law. So DHS, when information is redacted in according to what the law requires, and if we're going to be talking about the information that we're taught that should or should not be released to the public so that they can be more vested in the process, I can assure you that's something that personally I would love to see happen. I would love for the public to be more vested in the process. To the extent that the gruesome brutality that some of these children suffer needs to be made apparent, I'm not sure I see the benefit in that. If, finding out that a specific child suffered at the hands of her family in a horrible, gruesome way, I don't see how that helps the public become more vested in the process. But perhaps we run in, there's a very delicate balance that Tom was alluding to, that you have to balance the interests of the valid privacy interests of the family members who committed that crime. You have to balance the interest of any remaining siblings in the home, and you have to balance the interest of the child that was truly the victim of that abuse with their valid judicial interests, their criminal, or their due process rights, should it come to that. There's a lot of balancing that goes on. So should any of the advocates, any of our legislators deem it appropriate to make changes or take these considerations, DHS will continue doing exactly what the Georgia Code permits us to do. So, thank you.
Thank you. Sorry about the clumsiness of this. Many of you alluded to, all of you alluded to, I think, the balance of interests here, and those are all, as was noted, expressed firstly in the Child Abuse Prevention and Treatment Act, which is a federal law, enacted originally in 1974. There is a nonprofit advocacy group called First Star that periodically releases reports looking into this balance of interests, and the states enact their own state laws addressing public disclosure of near fatalities and child fatalities. It's called the State Secrecy and Child Deaths in the U.S. report by First Star. Georgia, this is now the second edition that was released in 2002. Georgia had been upgraded to a B from a failing grade in 2008, largely due to a bill that passed in 2009 that brought the state law into compliance with federal law, which had just changed to require the public disclosure of fatalities and near fatalities. The state, however, falls short of an A, of an excellent grade, because our law remains vague and unclear with a moderate restriction, is how they classified it. So really this all goes to the question of, in your opinion, what kind of information, what is the nature of information that the agency should be required to release?
That report is interesting, and I've looked at that pretty extensively. It cites the 2009 law that, excuse me, the phone is ringing, excuse me, I'm sorry. It cites the 2009 law, which was intended to bring Georgia law into compliance with CAPTA by adding the issue issue of children who suffer near fatalities. At the same time, an amendment was added to the bill late in the process that even the sponsor can't explain how it got there, that essentially wiped out several years of precedent of allowing the department to release complete unredacted files in the cases of child deaths that occurred within 5 years of defects intervention in their family. So we took a pretty giant step backward while passing a law that was designed and billed as a step forward. So that has created all kinds of problems. There are also statutes that provide for access to full records for people who have status as legitimate researchers, which in the past has included the newspaper. But now, with the new law, that seems to conflict with that. So that bill in 2009 seems to be the source of a lot of the tension that's here now, from our perspective. I mean, so I think in general, it's also worth noting that CAPTA allows states to release names of children who have died or who have been subject to near fatality, names and other identifying information. It's not required, but it is allowed under the federal law, as I understand it. So I guess from our point of view, again, it's the idea of whether it's helpful to know the details of the kind of suffering the child went through. I would argue that it is. I think it makes people care. It's a simple human emotional response that to know that a child who ends up in a horrible situation, such as one of the ones we had recently here, the child was starved to death and then burned and thrown into a trash can. I think that's important. I think it makes people understand that these are really horrible situations that deserve some kind of response. And I think you don't want to make it too academic or too theoretical. I think people need to know the actual facts.
I kind of tend to agree with Alan to some extent. That I think in 2009, we tried to make an effort to actually open up the law more, and I think we maybe inadvertently, the law of unintended consequences, so to speak, ended up perhaps closing ourselves down a bit. The law, just to remind y'all, as it was changed in 2009, says that the records for children who were involved in a fatality or near fatality due to child abuse are open, except that any identifying information, including but not limited to the child or caretaker's name, race, ethnicity, address, or telephone numbers, and any other information that is privileged or confidential, shall be redacted to preserve the confidentiality of the child, other children in the household, the child's parents, guardians, or caretakers. And I think that what we have created in that is a situation where when you have a system that is already focused on confidentiality, then what probably it's viewed as we need to preserve the confidentiality. And of course, I think what I see too often, is that especially in cases involving such as, Monty Moss or the Forbes child, terrible tragedies, this information comes out anyway. It gets out into the public, but all they know about really is the gory details. And what the value I see, and I think the value, if you look at the legislative history of CAPTA, the value that Congress also sees in releasing this information is not to release the gory details. It is to help those in the public, and especially those of you in the child advocacy community, the legislative community, and in other agencies, to understand how we can improve the process. And so I think what we might need to consider doing, quite frankly, is going back and taking a look at the policy. And I know, Rachel and the department, they are constrained. They do have to follow the law, and I think the way the law is written right now, it constrains them. But I would suggest that if you look at the Federal Child Welfare Policy Manual, that at least under the federal law, we're allowed to do much more. One of the questions is that there's a series of questions of the federal guidance for implementing CAPTA. One of the questions, sort of FAQs you might say, is what is there information that the state must disclose to the public? And states must develop procedures for the release of information, including but not limited to the cause and circumstances regarding the fatality or near fatality, the age and gender of the child, information describing any previous reports or child abuse and neglect investigations that are pertinent to this incident, the result of those investigations, and the services provided by and actions of the state on behalf of the child that are pertinent to the neglect or abuse that led to the fatality. And these, I think, if we try to restructure our policy a bit, I think we can get to the point where we're providing the information that allows especially thought leaders and legislative and other leaders in the community to say, let us look more carefully not at the terrible outcome. Of course, that's an issue. It causes us to be empathetic with the family, with the child. We do need to protect that child. But let us see how this process is working so that we can better protect other children from undergoing the same tragedy. And I think that, this is not just the job of me or Alan or Rachel, it's the job, quite frankly, of all of us.
Well, with respect to what the department currently releases, I don't know how many of you have ever looked at a child death report that has been requested through the Open Records Act. I'm not here to argue on behalf of the department or against the department or against any of the panelists. I just want to make it clear that it's understood that what is currently released as part of those open records requests are the names of the caseworkers, the actions that they took. What's redacted is the name of the child, the name of any of the siblings, names of parents, anything that's available in the, anything that we're required to redact pursuant to OCGA 49.541E, we take out. Everything else remains available. So to the extent that we're able to provide that information to the public, the department makes every effort available to do so. In addition, we do have statistical data available online. We categorize the child deaths in different categories, for lack of a better word, by maltreatment, accidental deaths, unknown when the coroner has been unable to determine whether or not what the actual death was the cause of, suicides, medically fragile children who it is expected that they will expire during their course in custody. So when we're, again, talking about what needs to be released, obviously I'm going to leave that to the public to determine what needs to be released, but before we get to that threshold of what needs to be released, it's very important to know what already is available. So.
The actual redactions, I would say maybe go a little farther than just the names and the identifying information. For instance, all the reports that I've received have the gender of every single person in it removed. Whether that person is the victim, a parent, another child, a police officer, anyone, even the gender is removed. I requested one report that referred to someone in the family having attempted to get a job at a particular gas station. The name of the gas station was redacted. I have no idea how that is a protected fact. So there are, it does go beyond the basic identifying information, and that includes the sections that describe what the caseworkers have done. Most of those that I get are pretty close to incomprehensible in large part. And some of that comes from redacting things like any kind of medical, basically the injuries received that a child might have received in an abuse case. And I know there are HIPAA requirements there, but in that case, the department really is not a provider as of medical services. So I think that we need to think about the reality of the way the redactions are done, in addition to what the law allows. And I understand that people who do that want to make sure they don't let something slip through that they shouldn't. And I don't think it's bad faith at all. I think it's just there has been a period of years that this has been building up. So it just is, it's an issue that we need to think about just in terms of how, whatever law we have, whatever restrictions there are, how they're actually carried out.
Thank you. Yeah, I should encourage you all to respond, freely, not to just stay in a sequence. I appreciate that through this conversation, I've identified sort of the following policy goals, and I think these capture them. We have, an interest in family privacy and protecting the privacy of the family and the best interest of that child. We have an interest in the public's right to know, and sort of conversely also with what system accountability should be and transparency around the work of our agency. So with respect to juggling all of those policy interests, what do you think actually, by way of individual case level information and or the aggregate reports that the department has recently begun making public, what is the information that is sort of in the spirit of the public's right to know? And I think this question probably goes primarily to Alan, you and Tom.
I think the identity of a child who has died after state intervention should be public, as is allowed by federal law. I think any description of what state employees have done or failed to do, any kind of assessment. I know there are reviews of cases. I think what Judge Deal was talking about earlier about the after action report is an interesting idea, and there is some of that there. But it would be important, I think, for people to see exactly what kinds of decisions were made by state workers in these cases, what kinds of decisions weren't made, and not just what the decisions were, but what they based that on. A lot of times it's just hard to assess what happened, not knowing the background of that they knew going into it. So whether something was, it's hard to tell whether an action was reasonable if you don't know why they made that decision. So I think that would be important to know. And that would, in many cases, I think would explain things to the public very, very clearly. So I think that's the basic information.
Well, let's talk about first about what we certainly think we should redact. In the case of a near fatality, we certainly need to redact the name of the child because we don't want him or her Googling himself later on and finding out these, just compounds the trauma. The names of siblings, certainly. I think the near fatalities are a little closer, but I do want to emphasize a couple of things that let's go back to the, for example, the long-standing journalistic practice has been not to identify rape victims, okay? And I think that sort of sensitivity, I think generally has led the press as a rule, moral, ethical rule, to avoid anything that would bring attention to that particular victim or identify that victim. So there is no reason you shouldn't have a little bit more confidentiality with regard to near fatalities. At the same time, many of the situations we deal with are, at least certainly the child abuse and more serious neglect situations, do result in fatalities, so we're not necessarily protecting the confidentiality of the child's deceased. I do not see much reason for us to protect the confidentiality of individuals who have been charged with crimes against children. And then generally, what the kind of information that, you know, in my former work as state child advocate, in continuing work, what I need to be able to see, and what I'd like for other professionals especially to be able to see, is how do we respond to these cases? What actions have we taken before? Were those actions effective? Was there any connection between what we did before or did not do before and what happened eventually to the child? The truth is that I think that when we have over-redaction, that what happens is the assumption on the part of the public, especially my friends on the Fourth Estate, is that if it's redacted, then it must not have been done well. There must be a problem. And so I think as state leadership, that we, those in state leadership, really need to think about sending the right message, which is give as much information as possible about the events while protecting the identity perhaps of individuals whose identity deserves to be protected, so that the public can both critique us and praise us when we are doing things right, and thank us for the hard work that is being done, whether we're a frontline social worker or administrative agency head or whatnot.
Yeah, I agree with that. I think what we see a lot is situations where it's really difficult to tell how bad a situation was in a family. For instance, there are many cases where a baby will be born to a drug-addicted mother, and you can figure that out simply because there's a reference to the mother had been taking, it's redacted, and so on, but you don't really know what it is. In some other reports, you're able to, some other places may be able to find it out. But whether, it would seem to me important to know that caseworkers have made a decision to send a child home with the family from the hospital when the child, if the child came to the hospital, was born actually drug exposed, and that the mother had a history of meth abuse, for instance. So that's the sort of thing I think can be dealt with without necessarily compromising too much confidentiality. It's a tough, very complicated subject. I mean, I'm glad I don't have to make the decision.
I think sort of jumping off of that a little bit, and Rich, I didn't mean to forgo you. I assumed that was a question that you might leave to the others. Okay, but I didn't want to pass you up. Feel free to grab the mic at any point. And so I just wanted to sort of use this as a springboard. If the goal of further disclosure, as we've talked about it, is in creating a greater opportunity for public engagement in this system and around these families, here you have a room full of child advocates, legislators, other thought leaders in this area. What would you say is our responsibility to make sure that if more information would be released, that the public would be prepared to consume that responsibly and thoughtfully in a way that would actually promote the kind of engagement that we're seeking, as opposed to further criticism, critique, etc. And I went off script. They didn't have that question.
I think we all have to basically give people ways to help. I've gotten emails and phone calls from people who've read stories that I've written who want to know what they can do, and I give them names of advocacy groups, and I to be honest, I assume that occasionally that somebody will follow through, and probably most of them don't, but at least they're interested. But I think we have to help them find out how to help. And if people have confidence that the system is working, I think maybe they will be more inclined to get involved. You know, my understanding is because of confidentiality rules, and sometimes it's hard to even get someone involved like that who is not in a formal setting or not in a formal situation like a foster care, foster parent or something of that nature. So it's difficult for people who really, really want to do something to help a child at risk to get into that, to actually get to be able to do that.
Y'all have probably, many of you in this room have been around a long time. You remember the Terrell Peterson situation in 2000 or 1999, around there. We had, as a result of that, a huge spike in children being removed. And we've had other crises in our system. If you look at nationally, DFACS or child protection systems are often go into crisis because of a spate of incidents. Sometimes those are just unfortunate numbers that just come in all at one time. But in what this causes in the system, these crises, in my opinion, is it causes the system to become unstable. Suddenly, policies are shifted and changed dramatically because of the public's demand. The legislature passes a new law requiring this or that or the other thing. Agency heads are changed because we need somebody tough or somebody more loving or just whatever the situation may be. And all these changes that continually occur, in my opinion, are one of the greatest threats to our child protection system, because they don't allow us to do what we should be doing, which is best practices in a stable, consistent, ongoing manner. Now, what's the greatest threat to stability in a child welfare system? It's an uninformed public. Because the folks in this room are the ones who know what's going on with the system, or should. Those in the child advocacy community. If you folks know what's happening with children, then you will get involved, and maybe some folks will write Alan and say they want to get involved, but y'all are already involved. So we have got to rely on the child advocacy community to inform the public, and we've got to rely on the child welfare system to adequately inform the child advocacy community. And so to me, the purpose, the real reason for opening up records to the extent we can is not so that Joe Smith down the street can watch on 11 Alive about, or Channel 2, not pushing any buttons here, about some child dying and say, wow, that's just terrible, and talk about it at the coffee cooler the next morning, water cooler the next morning. It is so that folks who care about these issues or who are involved in other ways, through as attorneys, as practitioners of medicine or psychology, as child advocates, can better interact with folks like Dr. Hill and say, hey, have you thought about this policy? I see that this is going on. I've got an idea. We talk all the time these days in technology and in business about crowdsourcing, okay? Some of the, like 3M and IBM, some of these other companies, if they have an intransigent problem, sometimes they'll post it on the internet and say, we'll give you $1 million if you can solve this problem. And so I think we need that same kind of informed public input into our system. And I hope that was the right question that I answered. I got a little off track too. But again, I think it's primarily a matter of making sure that the public, the informed public, the child advocacy community knows enough that we can keep our system stable at all times and always improve.
I just want to hit on, so I kind of agree with both y'all, but I want to be sure that it does not get lost that regardless of what the records say, if if there's a child that's being touched by defects, the chances are really good that their home life is not perfect to begin with, that they are in a situation where they are requiring state intervention. That in and of itself is fairly serious, and something that I think as child advocates, you all are, and legislators are trying to put methods in place to pull children not only out of those situations, but trying to prevent those situations. To the extent that the information currently available in a child record is not helpful, I would be surprised. Only because, I truly would, only because I think it gets back to the fact that DHS is, well, not even DHS, the law requires a certain amount of information release to those who are in a position to make a determination about child welfare. So while I think the message is probably heartfelt and well-intended, I'm sitting here listening, and I'm curious as to exactly what the goal is, because the department's goal is to protect the best interest of children. The advocate's goal is to protect the best interest of the children. The legislature's goal is to protect the best interest of children. And I think what we're trying to do is find a convergence point where we can all do that with the best information available. And what information do we make available? I just think it goes back to the initial question that I asked, is what information that is not already available would eventually get us to a point where we don't have children in the system. If you have that silver bullet, we certainly want to hear it.
Well, a couple of things. I think it's important also, we've talked a lot about defects, and this is not just a defects issue. In fact, one of the things that I found in reporting on this is that there often are a number of agencies and people who know a little bit about a child's situation, but they don't know what somebody else knows, and then that person doesn't know what the next person knows. And I wrote a story about a child, a 2-year-old down in Liberty County who died under circumstances that still haven't been quite figured out. He was found face down in a drainage ditch where he didn't drown, but he was murdered. So no one really knows what happened to this child. But he had been, the defects had a history with the family, the police had a history with the family, the military social workers had been notified about, because it was a military family, had been notified, but they hadn't told defects, and the police hadn't told defects, and defects hadn't told the police, and on. And so there was a lot of information there that no one knew. So that's one thing. But I guess the other point about, to me, the transparency, the importance of transparency, again, it goes back to the empathy factor, and I think it's most people probably will not get involved with this system or engaged with it, or even to the point of caring much about it if they don't see the faces. You can talk about 400 kids died the last year, or 450 or whatever it is a year, not just in defects, but it's say through the child fatality review process. You can talk about that, and that's fine, but showing people the one child who they can see and understand what was taken away in that situation, what could have been for that child, I think that is a very valuable tool that gets people involved and gets them to take part in making the system better and taking care of other children.
Just kind of to respond to Alan's comments, I do think we need this empathy factor. We do need to know the faces, the names sometimes, and I think that's helpful in terms of explaining to people the problem. But to me, it's showing the problem is not enough. We also have to somehow show the solution. Okay, and I'm afraid that what has happened in the past, especially with, and I'm not just talking about the last couple of years, but it's in general in our child protection system. Because I think the system, the folks in the system were constrained by different rules from explaining how the system works, what is done along the route, that you get a reaction that is an emotional reaction, an uninformed reaction that is simply a reaction for change, as opposed to informing the informed child advocacy community how these things are working and giving them the opportunity to tweak and make evolutionary changes in that system, as opposed to simply throwing out the baby with the bathwater, which is sometimes what can happen when you have a particularly egregious situation such as Terrell Peterson or the most recent deaths. It's not just a matter of knowing the faces and the names, it is really also a matter of explaining process to people through anecdotal stories of what happens with children. And of course, we're somewhat limited because the ones we do get to talk about are the near deaths and fatalities. We really don't get to talk about the ones where defects, well, for example, where the emergency room doctor got a case in and found out immediately that it was a bad abuse situation, and defects responded incredibly well and protected the child. So, I guess we could talk about that too, but that certainly is not even on the table right now.
Right. And I would say Dr. Hill has taken some steps to explain the process. When Amani Moss died a few months ago, really explained kind of what happened, what should have happened, what didn't happen, and I think that was incredibly helpful. I guess the other thing that happens here, though, we tend to talk mostly about cases like that are so awful and so sensational, and there are these abuse cases. But in fact, most of the kids who die from neglect, and it's not very exciting, right? To hear about it doesn't get people going, up in arms that way. So that it would be good, I think, if we could talk as much as possible, in going forward about the realities of what kids go through and what happens to them and what could be done to help them.
I just had a moment where I realized that Tom and I have worked together closely for too long. Because my next question actually was something that you alluded to unknowingly, which is, our demand for accountability comes from the outrage we all feel when we know that a child has been seriously injured or has died. That is a clear failure, and we're looking for both accountability from the parents as well as perhaps from the system that intervened. And so, and our focus around disclosure has been on those kinds of topics. How do we, and we don't talk about disclosure in cases where things end well. And that's because the interests of the family, the privacy interests certainly trump in that instance. But how do we present a more balanced message about the complete work of the agency with respect to all of the families that it intervenes, knowing that the fatalities really do represent the extremes?
I would love to be able to write about the day-to-day jobs of caseworkers. It's tough because for me to ride along with one, it exposes some people's privacy, or invades their privacy to some degree, or it could be seen as that. So, I think that I'd be very open to that. I think it would be very helpful if, people have a general idea of what caseworkers do, but I think most of us don't really know how bad it is and what a horribly tough job that is for people who really care about kids and who are doing what they do, probably not for a great deal of money compared to what they can be making elsewhere. So I think that would be immensely helpful to see how this happens, what the day-to-day life is, in the agency. Unfortunately, it does seem to, the big crises are the ones that come out.
We could probably arrange some sort of ride along. other than what I kind of mentioned before, this work is really complex. And what I have run into way too often is, it's like with a lot of, you've seen those things that everybody put on Facebook for a while. They were kind of going around, this is what, my mother thinks I do, this is what, my friends think I do, this is what I really do. And I think that with regard to child protection and child welfare, there really is, because we tend to focus on the fires, the crises, the worst case scenarios, that what people get is the idea that all of this is tragic work. One thing, at least we did a couple of years ago, is we started by opening up juvenile courts to some extent in dependency cases. And in that situation, for example, and of course you can't make people come in, you can't make people take an interest in this work, but when people do have an interest in this work, they can in fact find out the good things that are going on. They can become a CASA and not only expose themselves to the bad outcomes, but also to the fortunate outcomes. They can go to National Adoption Day every November 20th, I think it is, and see children who are being adopted out of foster care. They can work with groups like Empowerment, who, children who have been through foster care. But a lot of it, quite frankly, is going to be and will always be people who care about this line of work, maybe because they always wanted to do this, or maybe they're like me and they fell into it, and then they found out that this is something where I can make a difference. And I think so. We need to do as much evangelization, so to speak, as we can for this type of work. But I think we also have to be content to know that a lot of this work is going to be thankless, and just thank people who do it.
It is thankless work, but it's thankless from the public. The children that these social workers help understand. Our social workers build relationships with these families, the foster families, the families that they're trying to reunify, and these children and their siblings. There are very deep bonds. I did a ride-along myself in September, and I've been with the agency 2 years, and I've never seen anything like it in my life. And it was a social worker who had been out of school. She had her I think she had her bachelor's. I don't want to say she had her master's, but she definitely had her bachelor's, and took me to the home of a medically fragile child and talked to me the entire way there, gave me the case history. We started talking about other families that she'd been to, other houses, got the backstory of this child who had been moved from Atlanta 80 miles away and then back again. So this woman had been her caseworker for 5 years. So she has a bond with not only the child, the medically fragile child, who upon first glance you would not even know would recognize her, simply because the capacity, you would not, as an outsider, understand that this child has built a bond with the social worker. The social worker has made contacts with 2 different foster families. The biological parents is working in this, for 5 months was working in a 80-mile radius to ensure that this child's care was maintained, and was seeing her on a consistent basis, and found time to spend 3 hours at her house. She has to go in and do what policy says they have to do. You have to check and make sure things are where they're supposed to be and talk to the parents, and because she's medically fragile, there's a heightened list of checklists that they have to pretty much confirm, but then sat down and talked with the nurse, and watching how she interacted with the child who's in a wheelchair and has a helmet on and nonverbal, and drew information out of the nurse and became friends with the caretaker, It was absolutely astonishing to me that somebody could be that relaxed, that engaging, that interactive, playing with the child the entire time. This is a child who, for all intents and purposes, would have been sitting in a corner doing nothing all day long, absent some interaction from DFACs. And the foster parent, that whole situation is a wonderful situation. And to be part of that and to see the work that our social workers do on a daily basis, that's not a one-off, that is the norm, is truly astonishing. And again, something that nobody is going to thank her for. Nobody is, because that's not how it's designed, and people don't wake up and say, I'm gonna go work for DFACs because I need to be applauded for my job. They get up because they're driven. They get up because they know they make a difference. It is imperative that, I think anyway, that as a state, that we at least acknowledge the fact that there are people who get up every day and do that. The fact that I was afforded the opportunity to go on this ride along simply by virtue of what I have to do. I have to be able to understand what comes across my desk. So I was afforded the opportunity to do this ride along. Was astonishing, and to know that based on her stories, she spent her Saturday. Her Saturday was spent at an adoption fair, so that she had 2 brothers who were going to be adopted, and that was the last time that she was going to get to see them. I mean, it's touching because she is pleased for them, but knows that she's not going to need to be around anymore, which is best case scenario. But DFACS does an enormous. They do an awful lot of wonderful, wonderful things, and the work that the case managers who truly are social workers, they're licensed social workers. They do an amazing job, and like you guys said, it would be wonderful to get up and say, look at what we did here and look what we did there, and see how these fantastic stories, but we don't, because we're not allowed to. And that's okay. I mean, it's okay for that, because the child's best interest is protected if he or she can go and live a normal, happy life.
Thank you. And so we have a couple of things going on sort of in the various public policy spheres. One is, as I mentioned before, Representative Oliver has a proposal that's pending before the General Assembly, or will be introduced formally very soon, addressing some of the laws that we've discussed today. But also, if you are not aware, in 2012, Congress passed a law called the Protect Our Kids Act, which created, among other things, a National Commission on Child Abuse Deaths. So obviously this conversation is not one that is just local here. And I just am curious, without even knowing necessarily anything about that largely is a commission that's created to take a look at these issues and make some recommendations, and not further parameters aren't really spelled out in that act. But I'm curious, what would you like to see from that commission or from these local proposals? How do we make this better?
I'm not really in a position to advocate, but I think in general the idea of transparency is important for another reason, and that is, I think it kind of destigmatizes the issue. No one should be ashamed to grow up in the fact that they were a foster child, or that they had to have some help. It's not a terrible thing, really, in and of itself. So I think if there's a way that it can be made to be less something that people feel bad about or feel sorry for you, and maybe more empathy and less sympathy would be good. And how we get there, I'm not sure, but that would be my thought.
Well, I think anything that we can do, and I think transparency is following now. I think transparency is of value in this work because it gives the potential for us to improve the work. Okay, the whole point of child protection is not to respond to a child death; it is to protect children, to prevent them from falling into this kind of situation, to intervene in families early enough that these kind of tragedies do not occur. And so we need to be working not only on our response system, but also on our prediction system. So for example, DFACS right now is working with a very bright consultant on putting together some predictive modeling. And it takes lots and lots of data, okay? We're gonna have to get data from public health and from hospitals and from other places to be able to put together a model that will predict, when children are really at risk. And then to implement that model, we're gonna have to have lots of data about children. We can be afraid of all this data, we can be afraid of getting all this information together, be afraid that it may be misused in some way, or we can see both transparency and data as tools to allow us to make our work more efficient, more effective, less expensive, and really, in the long run, to prevent more children from being abused and to protect those, and I don't want to say rescue, that's not the right word, uplift and surround and care for those who are in bad situations. So I think a commission, national commission like this, ought to be focused not only on, Lord have mercy, what happened to these children, but let us take these lessons and figure out how we can do a better job in the future.
I'm not sure it's appropriate for me to comment on that. There you go. Thanks.
With the panel's indulgence, my thought is that many of you might have questions that I have not answered, and so I certainly would defer to the legislator, who was quick on her feet. So I don't know if I can get this to you. If not, I'll repeat it. It might reach you, Representative Oliver.
Thank you, Melissa, and thank all of you. For the purpose of this informed group being engaged, which I know they want to be, I really want everybody to look at the specific language of the pre-file 705 bill. I'm going to get into the weeds for just a second, and then I'm going to ask you how to solve all this. There's law that protects criminal investigation files. There's law that says who owns a child's medical record, i.e. the estate of the child. There's FOIA, and then there's the child fatality review system. All of that is in conflict with each other on one level or another. And solving that is very difficult. I think the legislative intent of the child fatality review is prevention. And empathy is on the path to prevention. But if we can't make the child fatality review process work, or as a goal of prevention, should it be maintained?
I won't. Probably shouldn't say whether it should or shouldn't be, but the reality is it's not particularly effective now, and I also don't want to give away too much of what I've been working on, but there's some issues there, to say the least. What's interesting, I think, about that is Georgia had, I believe, the first statewide child fatality review panel in the country, and it was seen as something of a leader in that area, and I don't think that now we are regarded as such, as far as I can tell.
The function of the review is appropriate and necessary, but I don't necessarily know that the way we've been doing it is the best. The idea of doing it on the local level, of course, which is traditionally how we've done it, you get different modes, you get different ideas about how to review things. But I think in the longer run, the real issue is not to review the fatalities of children just for that one's sake. It is to review it for several different reasons. Number one is the public health function. So Dr. Jordan Greenbaum at CHOA, I think, has done some work around identifying children who come into ERs and who suffered abuse and how we're responding to that, and whether or not we're catching it. And so that's how we need to have a review for that purpose. We need to have a review for the purpose of identifying how we're treating medically fragile children, because that's a lot of those issues. Practice and policy around when do you send them home, how you send them home, how they're cared for in the home, whether or not the Medicaid or insurance is covering it adequately, that kind of thing. And then, of course, the issue of children who've died from abuse and neglect. But I don't necessarily know that the current way we're set up, which is this general child fatality review, is adequate to that task.
I can say I'm reviewing the bill and looking at it in relation as how it relates to, you know, the Open Records Act, FOIA, and the other acts that you mentioned. And the department, just, as you know, we don't comment on pending legislation, but I am looking at it and but find it very interesting.
Thank you, Melissa. I just want to make one comment because I really want these folks to look at that language too about how to improve it. You do comment on legislation in the back rooms, and I'm not. You have lobbyists. You have. So I'm really looking for an open discussion as possible through your lobbyists and through the governor's office that I know is really studying how to solve some of these conflicts. We need a very specific discussion, and I asked the question provocatively, intentionally, because I was involved in the original bill, and I just think strongly that it's not achieved what it could have achieved.
Thank you. Anyone else in the audience have a question for our panel?
You mentioned redacting records. I wasn't aware of who does that. I thought the DHS did it, but you said it wasn't done by anyone that had a dog in the fight. It was done, and I didn't know who it was done by.
Yeah, thanks for calling in.
The redaction is done by DHS. So when I say it's not done by anybody who has a dog in the fight, DHS as an administrative agency has a vested interest in ensuring the welfare of the child, but from a legal perspective in the release of records, ensuring that the letter of the law is met. So we don't have caseworkers redacting records that they've worked on. We don't have caseworkers redacting any records, quite frankly. That's done within the Office of General Counsel at DHS. So we will pull a case, the process is to pull a case record from our system, have pages 1 through 900, however many pages there are, assembled, and then hand-delivered to one of the attorneys who will then at that point begin redacting without regard to who's involved, what the actual facts of the case are. So it's as impartial as we can be within the four walls of our agency.
Who is the public relative to, I can understand Alan's frustration at trying to look at redacted stuff and putting the pieces together. If I'm in law enforcement in Cherokee County and I'm trying to do something right and I need information, where does the redaction to protect the child's privacy issues in the public happen versus someone who is working on behalf of the child, maybe in another agency, and they need information? Do they run into the same circumstance as the reporter from the AJC, or do they have access, or she have access to facilitate preventing something bad happening that is part of whatever they are investigating?
So the Georgia Code at 49.541 provides for several situations in which child welfare records must be released. It provides for several situations in which child welfare records are permitted to be released. And specific to your example, sir, Any adult, well, I think it's actually, yeah. Any federal, state, or local government entity or any agency of any such entity that has a need for the information contained in a report to carry out its legal responsibilities to protect children from abuse and neglect. If a law enforcement officer is working on a particular case and requests a file pursuant to that, we would be able to release that record. I mean, so. The question was with regard to teachers and when they report abuse, what information do they receive? And I know there's been an awful lot of communication between the media and our Legislative Affairs Communications Office regarding that. I'd prefer not to get into that since we've got so much communication. I'd prefer to have that specific communication in front of me. Alan, I'd be more than happy to talk to you off record. If anybody has any questions, we'll be more than happy to submit to you what we've submitted to other media agencies if that's where you guys would like, if that's information that you would like more detail on.
If I'm gonna allow myself to comment, I would say, DFAC's policy does require that mandated reporters be given notice of the disposition of their report. And so that's not the same kind of thing as a complete record, redacted or otherwise, but just the nature of what happened. Was it screened in, screened out, and how was it triaged and assigned? So that's one partial answer, and I'll leave the rest to you later.
Thanks. I just had a question relative to DHS itself. You went through a beautiful example a while back of this lady that you had worked with and what have you, and the job that she did and how impressed you were with that. As I was sitting here listening to it, the first thing that came to my mind was, what did you actually do with that information to promote and build up your agency itself? Where did that go? I mean, did DHS take a look at that and say, how can we make our situation even better? It's one thing, I got the feeling as I've listened to you a lot, that there's a lot of reaction. What you can't do, what you can't say, what you're not allowed to say. I haven't heard anything about what you do and how you take positive information that you've gotten and say, yourself, even as an agency, what do we need to do to get better? What do we need to do? Even bringing something to the agency itself and saying, here's some ideas, here's what we're seeing. I think that would go a long way in terms of we talk about building public trust and educating the public. A lot of that has to come from you, as an agency. So I'd like to comment on that.
And I think I brought into the whole panel because I think each of us, including your moderators, is involved in certain activities to do just that. And so I'll ask how each of you has been involved in ways to build up sort of the public image, the public trust, to celebrate the good work and support the workforce.
And find out the problem areas.
For us, as I said earlier, I think it would be really helpful for us to be able to do those kind of ride-alongs and see the reality of the day-to-day work that's done. We are not really have not been able to do that up to now. And we're also, I know I'm very interested in the whole predictive analysis issue. As you look at cases and you see so many times there's so many factors that are similar in case to case to case. And there's a lot that can be done here. So we're obviously we tend to write stories about things that go wrong, and that's just the nature of what we do. But we're not obviously we're not opposed to writing one if when things go well either. So in fact that would be great.
From my standpoint, these days I've been doing a lot of work lately with the Supreme Court Committee on Justice for Children. One of the things we do is we go around and we have, it's all in Michelle Barkley's purview, we do data presentations to judicial circuits, to groups of mixed juvenile court judges, social workers, CASAs, juvenile justice folks, that kind of thing. And we talk about the data for that area. We talk about what's going well, what's not going well. We look at the numbers, and we celebrate things, and we also point out where there are weaknesses. And I know John Glenn's been part of those in the past. I think those are very helpful. And I guess I can say Melissa and I are also working lately with DFACS and doing some external review on some of these latest child deaths and doing some policy review. So, and I think all of you out there who are involved in this work, I think the real key issue for us all is to be friendly critics, if I can use that term. You know, it's working in this field and working with agencies and working with tragedy. It kind of reminds me a lot of times of raising my children. I don't want that to be taken the wrong way. But, you know, I have a 15-year-old, and so, you know, those of you who've had a 15-year-old know how that can be sometimes. And so it is always a very careful thing, very careful process of praising him and also holding him accountable in a very gentle way. And so I think that really is what we all need to be doing, is both showing praise but not blowing anybody's head up. You know, don't make you think you're too great. But at the same time, when we do criticism, to do it in a gentle and uplifting and building way. Because as y'all know with 15-year-olds, if you don't do it right, they just shut you down and don't listen to you. So I think for me, all of this work, whether it's presenting data, whether it's working with DFACS on these issues, is about doing so as a kind and gentle person who is also can be a critic, but in a way that is constructive.
And to your point, I think we have done an awful lot here today talking about what we can't do, specifically because we're talking about open records and there's legislation on there's, as Representative Oliver mentioned, there's legislation that is pending, there's current law about what we can and can't do with open records. But specific to what we as a department do to boost them around, to tell our employees that we're doing a good job, that they are doing a good job. Never assume that the department itself, I'm just saying that the employees go out every single day, the social workers do, and do a phenomenal job. So what we do to get that message across has really morphed and changed over the course of the last even 6 months to a year. And the department has truly recognized, leadership in the department has recognized that there are literally thousands of unsung heroes every single day that wake up, get their badge, and go to work. The same can be said for our foster parents who take it upon themselves to bring these children into their homes where they may already have children and assimilate children who come from environments that are not stellar to their home without, trying to bring them into a new environment where they can learn and grow and prosper. So to the extent the department can, we've created Facebook pages. We encourage you to go to the Department of Human Services Facebook page. Whenever we have anything good that happens, the commissioner's first question is that on the Facebook page? Which is kind of nice. Because it's not an environment where there are a lot of good things that people recognize as good. For instance, the ride-along that I was fortunate enough to be a part of, I had to stand up and tell the entire leadership team about it. That's 30 people in a room who are not necessarily DFACS. So we're making sure the child support unit and the aging unit and the Office of the Inspector General and the facilities unit are aware of what our social services case managers are doing. We've got an 8,000 person agency. If we could start getting that message from our case managers and DFACS down to everybody in the agency, it's sort of the trickle-down effect. Everybody will start talking about some of the really good things we do without releasing any of the confidential information. Our communications office consistently has, like I mentioned earlier, we've got dialogue with the media organizations. We've spent years building relationships with these organizations, with Alan and other reporters, so that we can call them and say, hey, it's summertime and we need to make sure that we have stories about, watch children for drowning. Drowning can happen in a bathtub, it happens in pools. Make sure that we have the PSAs out there. We do co-sleeping PSAs, PSA, public service announcement, that where co-sleeping is a #1 killer of newborn infants. It's hard to put the baby back in a bassinet. Do it. And continue to have this dialogue with the media, because they're a huge outlet for us. We have our website, we've got the Facebook page, and our people. And then obviously the advocate community. We've got our SAGs and our juvenile justices, and then people like you who are out there helping get this message across. So, and if y'all have any other thoughts, I'm sure we'd be open to hearing them.
And I'm sorry, I should have been asking all along if you'd identify yourself for our guests, but also for online.
Noreen Corrigan, and I'm a self-employed adoption consultant. What I was thinking while y'all were talking would be how helpful it would be for the public to know that the caseworkers have 60 cases and they have to visit them every month. That's the kind of thing, or that there is a template where they assess risks on 10 or 20 or 30 different aspects of a child in a home. Because this is a risk. You don't say, oh, they've done this only twice, so that they definitely won't kill the child. But everything's a risk. And I know one of our past commissioners said, the sad thing is that children will die. There's a risk. And I think he was fired after that. But that really is the fact that we're looking at risk factors like the weather. Is there a 55% chance this child will be okay? That isn't very good, but you've got to cut it off somewhere. So I think informing the public of what kind of caseloads, how much they have to visit, what they have to do and what they can't do, and the fact that this is all a risk decision. And I've worked for DFAS in the past for 10 years, so a little bit about that.
Michelle Barkley, I'm at the Community District, and I really appreciate what you had to say. That made me think a lot of a story that Dr. Hill, and I'm probably put you on the spot for just a second, it's a good story. You told me a story that you, over Christmas, you spent 2 full days with Clark Howard. And that's just an amazing story of what happened, the outpour of the public, and everything people did for you. And you were there 12 hours each day. So could you just tell the numbers of the gifts that were given?
Michelle, I actually thought it was going to be another story. Sharon Hill and, right, we did, Clark Howard does a Secret Santa campaign for us. And we purchased toys for almost 5,000 children. And each child had, their own wish list, 3 items on the list. And I mean, for me, I usually tear up about happy things, and I'll tell you, actually I was there probably 4 days out of the 6 that he did. And yeah, just the outpouring from the public. And I think really wanting to know more about what they can do to get involved to improve the lives of children. Because, I think probably the average expenditure per person was probably a good $160 that people spent on our children. And folks came in, even, this 12-year-old boy who came and he had his piggy bank that he had saved up some money to buy toys for children. So you're right that there are a lot of good things that's happening that, the public needs to be aware of.
We do have time if there's one final question. I didn't see as many eager hands, and I do think that's such a great note to Judge Deal. I said it was a great happy
I should have been quiet.
You opened it, so you can close it if you mind.
Well, this is more, it's hard to follow up. This is more of a practical question, maybe it's pie in the sky, but I mean, it sounds like the paper is a bit distrustful of the department about what they redact. And I think likewise the department is somewhat afraid of the gotcha game if they divulge information, also afraid of being sued if they divulge what they're not supposed to. But have y'all thought about perhaps coming up with a dummy report and getting together and working as a collaborative to say, let's do a dummy report, change the names, change the dates, change the name of the gas station, and let's sit together and let the department redact that report as they would, then review it with the paper, look at what was redacted, give reasons why it was redacted. If there are questions raised about why would you redact the name of the gas station, let the department respond to that. If it's a legal question, if it's, does HIPAA fly about the drugs that somebody was taking, at least we can formulate what are the issues, what is it that you disagree about? You may find that you don't really disagree about a whole lot, that they're redacting stuff that they should, but it just appears sketchy because it looks better than those big black marks do. But if you can identify, here are issues that we think need to be fleshed out further, then we can go talk to Representative Oliver or somebody else to say, do the legislation to fix this or make it clear. Because I think the department's going to give the information that they're allowed to give, and it's just a matter of building some trust between the different agencies. And I think that's an important part of moving forward is everybody's got to trust everybody and be willing to work together to try and come up with some solutions.
Worth way more than 2 cents. I think that's all a great idea. And actually, Dr. Hill had a few comments that she wanted to respond to some of the discussion today and maybe even that last point.
Right, yeah, and as Judge Deal said that, I made a note about that because I think that's perfect for our external review team to maybe take a look at that to explain. And I want to say that I really appreciate this forum, and I thought this was great. The story that I actually thought I shared with Michelle a couple of times, I started as an investigator, foster care worker back in the late 80s. And the very first case that I had when I came out of training, I was in working for Illinois Department of Children and Family Services, was a child fatality case. And it was kind of back to Mr. Judd's point about, agencies needing to talk. I went out with my mentor, first day on the job after training, and we went to the hospital to pick up a baby that had been born to a mother who had severe mental health issues. She had been released from the hospital, from the facility, actually taken to the facility with the understanding that as soon as her baby was born, the DFACS worker, me, would come and get the baby, and we would place the baby in foster care because we had a couple of our other children, and then she was to go back to the psychiatric facility. Well, when my mentor and I showed up at the hospital and I said, here to get the baby, and they said, oh, the mother had already left with the baby. So it took us probably a couple of days to track the mother down, and through some of her relatives, we found her in an abandoned building. Went in, and by the time we got there and was able to get inside, actually we had to call law enforcement to come. And she had already hung the baby from the shower stall. And so that was kind of the very first case that I had. So as I work these cases, I'm very sensitive to our case managers. That is a very traumatic experience, after dealing with something like that. But a couple of things that I did want to make note of as we talked, that I do agree in terms of balancing the child's best interest with what's the need to be transparent. And most often, because of my position, I'm certainly coming from a best interest of the child's perspective. And the thing that I really want to add to this has to do with being really sensitive to the surviving siblings. In most of the cases that we have of child death, there's always siblings left behind. And I had an occasion a couple of months ago to go out to visit, to the foster home to visit the surviving sibling of a child that was murdered. And this particular child, 10 years old, looks just like, her brother. And she's not in the same school that she had been in. However, the foster parent talked to me about just how heartbreaking it is because, for a while she had to keep the television off because that was on the TV. So, and then when she thought it was finally over, they're watching something on TV, and there's a preview that comes up. Child is sitting there, okay, we're getting ready to talk about your family. When she gets to school, you know, even though it's a different school, there are people in the school that has already associated her with this case that they keep seeing on TV. So she has everybody from, you know, well-intentioned teachers and, you know, people are just naturally curious. Other parents. So she goes to pick up the kids, you know, it's people saying, oh, that's her, that's the sister. So, you know, those are the kinds of things that the surviving sibling has to be able, you know, to deal with. And I think a lot of times that gets lost even, you know, we keep thinking about, as you said, the child that's deceased, but they've left somebody behind that I really want us to be conscientious about. Also, when we talk about what has to be released, I like the notion that you talked about in terms of an informed public. You know, that as we release information, there has to be some responsibility behind that release. And I definitely agree that, you know, child advocacy groups are the ones, because we have to explain things. For example, you know, as we even released our child death report for 2012 that said we had 152 child deaths that had prior defects involvement. Well, public automatically thinks that all 152 children were beaten to death, right? That's the image that they give because, again, I think there has to be some responsible release that we explain the context of it so that people understand that, you know, out of the 152, you know, 6 or 7 may have been, you know, related to some physical abuse. Most of them were accidents and those kinds of things. So I do think that there has to be, you know, a forum or someone to put it into context prior to the release. The other piece that I wonder about too is the need to release information about individual cases versus the aggregate, particularly if we're talking about engaging the public. For instance, you know, we have you know, children who die because of medical issues, and sometimes it's related to, you know, mothers' drug use or something during the pregnancy. Now, it's one thing to release just that one record of, you know, Tom Jones who died, you know, he had medical issues based upon the mother's problem. But I think for me, it seems so much more beneficial if we're talking about the aggregate, that there were 20 children this quarter that died as a result of this. These are some of the commonalities. So for me, you know, I guess I wonder about that need for the information about individual cases to help the public versus the aggregate to really say these are some of the things that we're seeing. This is what the public needs to know about the dangers of lack of prenatal care or drug abuse and other risky behaviors, you know, accidents and you know, those kinds of things. So again, I really enjoyed this panel and look forward to many more discussions and some work that we're doing with an external review team that really highlights, you know, what Judge Deal mentioned earlier, because I like that notion of the, you know, the after action kind of thing, which is what we're really looking at, you know, and that we can have a group that really understands the issue and can relate that information in an independent kind of objective way. As Judge Rawlings says, the friendly critics, which is what we certainly want. So, thank you.